Welcome back to Law and Crime. Now, there have been more developments in another case, the Murdoch family murder case for convicted murderer Alex Murdaugh. Now, the South Carolina Supreme Court, yes, the top court in South Carolina, will consider whether the disgraced South Carolina attorney could get a new trial on murder allegations because of jury tampering. Yesterday, the court granted the defense motion to assume jurisdiction. I mean, jump over the appellate courts and take it directly on one of his two appeals. And this is pertaining to a new trial for Alex Murdaugh based on the issue of jury tampering allegations. The court gave the attorneys 30 days to file their initial briefs, but it's still unclear whether arguments will be heard. Now, this is after Murdaugh's attorney brought to Judge Jean Toll, the lower court that had replaced the trial court, that there was evidence that the Colleton County Court of Clerk, Becky Hill, yes, Becky Hill, tampered with the jury and requested a new trial. But Judge Jean Toll later denied Murdaugh's bid for that new trial. And Hill later then resigned from her role of the Court of Clerk and faced two allegations by the South Carolina Law Enforcement Division. Now, remember, Murdoch was convicted of the brutal murders in March of 2023 for the shooting death of his wife, Maggie Murdoch, and his adult son, Paul. Murdoch was given 2 life sentences for these crimes. So with that, a reminder, I want to bring in both of my guests, Eric Faddis, trial attorney, Castilla Early. Now, Eric, it is unusual for a court to jump over an appellate court and take it, especially a Supreme Court. What does that tell you? Does that tell you that it's important? Does that tell you that he's going to get a new trial? What does it tell you?
It's pretty uncommon. It tells me that the Supreme Court has an important interest in this case. It might be defining the law, defining the standard that defense would have to meet in order to get a new trial. But usually there's what's called an exhaustion of remedies doctrine, where you've got to go through the Court of Appeals first, and then you go to the Supremes. The fact that the Supremes are taking it now just tells me that they have a lot of attention and focus on this case and think it's going to be important precedent for future cases.
Yeah, and I remember, Castillo, when the judge brought the jurors back in for the voir dire as a remedy, that I remember saying she's not asking the right questions. She's not asking whether or not they talk to each other. She's not seeing what really happened in between, you know, with all the jurors. And I thought that, and I don't have my notes on it now, but that her voir dire, which was a remedy, you know, almost like what we're talking about in the Karen Reed trial, to bring the jurors back, was insufficient to find out whether or not the tampering had actually been effective. So what were your thoughts looking back, thinking back to, yeah, and there she is, the star of the show, Becky, Miss Becky, the court clerk?
I mean, I agree. The whole purpose of having this inquiry is to find out whether or not justice was truly served. So you have to ask those important questions, and they have to be specific. Like, what exactly did you say? How long were you in the room? What papers or letters did you pass? You want to make sure that the questions that are asked are sufficient enough so that if it does get appealed to the higher court, that they'll say that, you know what, the lower court did exactly what they were supposed to do. They inquired, and we don't find that there were any sufficient evidence that there was any juror tampering. But I just believe that this was a small town that got caught up in this big, you know, star-studded event where cameras were in play and people just got over their heads, including the clerk of court, that should have known better to kind of keep those lines of communication totally separate. So I do believe, although Alex Murdaugh was the most hated man and there was sufficient evidence against him, everyone is entitled to a fair and impartial jury. And if the circumstances are true, he didn't have that chance.
And Ms. Hill wrote a book. She was writing a book at the time, and she had a co-author at the time. And so there's implications against her that could be criminal too. So this is a very important case for everybody, the justice system for both of them. But I'm losing both of you, Eric Faddis and Castilla Early. I know you'll be back on Law and Crime soon, but we're going to take a break. On the other side, we'll have 2 new guests, and I'll see you there. And good afternoon again, and welcome back to Law and Crime. I'm Linda Kenney Baden. Now, let's pivot to Florida for the trial of a Florida woman who was accused of fatally shooting her neighbor through her front door. Susan Lorincz is charged with first-degree felony manslaughter in the fatal shooting of her neighbor, Ajika Owens, okay? According to authorities, Owens was shot through the defendant's closed door after Owens went to speak with Lorincz about a dispute over Owens's children playing near the defendant's home. Lorincz is claiming self-defense, and she says that she did not intend to kill Owens when she fired that shot through her front door that also killed Miss Owens. She also called 911 after fatally shooting Owens and admitted right away to the shooting. The police interview of Susan Lorincz has been played in court today, so I want to head into court and listen in how she describes what led up to her shooting Miss Owens.
So they were being obnoxious out there tonight, and they finally got quiet, but then you go outside and the three of them are out there.
Yeah, and I didn't want to go any further because he's like, I'm going to kill you, I'm going to kill you. I'm like, what in the world?
Who said that?
H.I.'s kids.
Okay. So who is it?
H.I., I think her name is.
Okay.
She actually had thrown a sign at me before. She picked up the no trespassing sign and just threw it at me. She's like, here, take your fucking sign. I'm like, it's not mine, it's Charles. You know, he doesn't want you guys here. Mm. So it's just, you know, she's been in my mailboxes. She sends the kids in the mailboxes.
When did she throw a sign at you?
I want to say last year, just after I had my neck fused. I'm like, oh, good gravy.
What kind of sign? Like one of the ones you buy at the store, like a plastic, like on the
bed? It was a metal sign with a little metal, like a real estate sign. But it had no trespassing, so it was about that by that. And yeah.
Is it the same one that was out there tonight, or is it different?
Mm-hmm.
Okay.
They stole that sign.
So what happened tonight that led to the conclusion that...
Well, I'm like, kids, go home. So they go home, and then all of a sudden she comes out, and she is just banging on my door. I'm like, go away. I'm not dealing with you tonight. And then she started banging so hard, everything started shaking. And I'm like, you really need to leave. And then she's like, I'm going to kill you. And she's just banging away. You know, I'm like, oh, crazy. And since she has actually harmed me, I'm like, this just keeps getting worse and worse. I'm like, I don't know what to do with her. And she banged so hard, it looked like my door was going to fly off. And I panicked. And I was like, oh my gosh, she's really going to kill me this time, you know. And so I don't even actually remember picking up the gun. I just remember shooting.
Okay, so to discuss this, I have two great guests here. Sherry Botwin, who is a licensed clinical social worker and a trauma expert, and also criminal defense attorney, trial attorney, Fatima Silver. So I'm going to first start with you, Fatima. This is the charge of felony manslaughter. The state did not charge murder here. So does that mean that the state's crediting some of the self-defense?
I believe they are. This is a difficult case because she's the defendant here isn't very likable. You know, she sounds like the grouchy neighbor, not liking the children playing in front of her house. But at the end of the day, there is a sound self-defense claim. Ms. Owens was banging at the door. She was scaring the defendant in this case, and neighbors say they hear it and they're frightened. They don't know what's going on. And so we also have the play of there's different ages, different sizes. All of that is going to come into play. And I think that the prosecution took that into consideration when filing this. I do think a murder charge would be difficult in this. So manslaughter was the appropriate one.
So when I was listening to this yesterday, Sherry, the prosecution opened, they talked about how, there had been a roller skate that was thrown at the kids, and that the defendant said something like, well, I know what the kids are going to say. They're going to call the police on me. They're going to say I threatened to kill them, and I'm going to be the one in trouble. But the mother then comes, Ajika Owens then comes to the door to bang on the door and talk to her, like any mother would, because you went behind, and it's a metal door and all. So with that in mind, both sides here seem to have trauma, but there's only one person who's dead. And when I was listening to it, it sounded like, well, maybe the defendant thought she was in danger, but that was rooted in racism. Here is a black woman coming to my door and banging on it. So that was my takeaway. I don't know what you think about the trauma related to all this.
I mean, I felt and still feel the exact same way. It feels like there is a lot of anger there. There's judgment. And it does feel like her reaction to what these kids are doing, it's out of proportion to what really happened. Her reaction seems very strong. And in terms of the mom coming over and confronting her, you know, as a mom, when people are yelling at your children, it makes sense that she went over there and confronted Susan. And again, I'm not exactly sure how she did that. And like you said, maybe they both played a role in this, but the outcome is it's devastating and it didn't need to happen.
No, it didn't. So I'd like to listen to more of this interview and have a longer chat with both of you on the other side. Let's listen.
One thing that I think my partner was trying to get at, and I don't know that I actually heard an answer to the question. When you're inside the house and she's on the other side of a door that you can't see through and she's pounding on the door, you make the conscious decision to aim your gun at the door and fire one round, right? Just one round?
Yes.
Fire one round. Were you trying to hit her, or were you trying to scare her off? Were you trying to make a loud noise to say like, hey, I got a fucking gun, get away from my door? Or were you think like...
I was never intending to hit her. I just thought, I thought I hit really high, you know. I was just like, kind of, you know, it's the first time I ever really used it where I was, you know, like...
Not on a paper target.
Exactly. I was like, oh my God. So I was shaking. I mean, I was just so distraught at that point in time. I'm like, oh my God, she's really gonna freaking come to my house. And I was just like, all I could think is go away, go away, go away, go away.
Did you mean to, were you aiming for the door?
I just fired the gun. Because all I could think of is, I felt like I was in mortal danger. I mean, it's just how I felt.
And again, I can 100% sympathize with being fed up with that kind of harassment and that kind of disrespect. But also someone lost their life last night, right? No?
I absolutely feared for my life.
So this is...
I mean, this was an absolute, it's either me or her. I mean, it's just like, holy shit.
Did you see her with a gun or another weapon or anything like that?
I don't know what she had on the outside. You know, when my lights were off, you know, so she came up, it was dark out. And I'm like, great, now she's pounding on my door. Now she's scaring the crap out of me. You know, now my door's moving. And I didn't have it properly secured. And the next thing I thought she was going to be in my house, you know, killing me. I mean, that's honest to God what I felt. You know, it's not like, you know, I'm fed up or anything. This was a real fear.
But when we first started talking, you said you made it very clear to the 911 call taker that she was threatening to kill you.
Yes, absolutely.
And if that's not on the recording, is there any reason why that's not on the recording?
I have no idea. I'm pretty sure I said it. So.
Are you just pretty sure she said it as well? That she
no, absolutely, she said it.
Fatima, unlike others, I think the defense is a very difficult case here because she knows how to call 911. She could have gone into the bedroom, closed the bedroom door. If indeed Ms. Owens intended to kill her, break down through the door and come into her bedroom door, then that may be a different story. But I think that I think she was scared, but I think her being scared is irrelevant because it was rooted in this kind of like fear of a black woman. And, you know, I don't know if you can say that in court, but that's how I'm feeling, Fatima.
I agree. I believe that everyone's going to see it, right? There is a race issue here, whether it's mentioned, and that is going to come into play when the jurors are looking at who the victim is versus the defendant. I do think the defense team has a difficult job here, not just because she could have retreated. Let's keep in mind, this is Florida, stand your ground laws. They're pretty liberal there, but also because this is a defendant who is strong, has shown a strong personality when it comes to everything else, right? She's getting angry at these children. She's yelling. She threw roller skates. She's caused problems before. So it's going to be a little difficult for the defense to paint this picture of this timid, frightened woman now when she wasn't like that before. But once again, there are some issues that I think are going to play in her favor. She can't see through the door. She doesn't know where she's shooting. I think that's important as far as She says she aimed high if she was unaware how tall Miss Owens was. In this case, she's not directly aiming at her through a window or anything like that. So there are some things that are in her favor, but I absolutely agree. It is a difficult case for defense.
Okay, so Sherry Botwin, in her court personality, her court presence right now, she looks different. Her hair's a little darker, grayer. I mean, she really looks like a sad sack. But in her interview, she did appear to be telling her truth. I mean, it didn't appear that she was lying about what she believed. She appeared to be telling her truth, and she did call 911. So would you advise the defense team to put in any type of, that she may have some type of psychologically diseased personality, some kind of a treatment that was needed under the diagnosis statistical manual for her psychology? As the reason why she feared this woman? And would that help at all?
It's one of the things that I've been wondering as I've been watching the trial. When I watch her in the courtroom, her affect is so flat. She's looking down. At one point, it actually looked like she was drawing, not writing. So one of the things that I was thinking about and continue to wonder is this a woman who is paranoid? Is this a woman who has thoughts that may be more delusional? I think if they were to conduct some type of psychological evaluation, we would find out more about what's behind her reaction to even just getting the gun. Because again, like both of you are saying, a mom who comes over knocking on the door and is angry, while that can be upsetting and intimidating, that doesn't sound like a situation where someone's life is being threatened. She didn't have a weapon in her hand. So I think it's an important piece, and I'm not sure if this is part of what the defense is going to be doing in the trial, but I think it really is needed. So we'll have to see what happens with that.
And Fatima, she's already given a statement to the police. Is there any need as a defense attorney to put her on the stand now to say she's sorry, to apologize, or to do anything to the jury that may help her in any way? Or as I sometimes say, putting a defendant on the stand is the quickest way to go to prison. But, you know, that may not be the situation here. Do you see any difference here?
I don't think in this situation I would. Anytime you put your client on the stand, it's a very risky situation. You don't know how they'll come across. I do think in her interviews, she comes across as genuinely frightened, scared, and remorseful as well. So I don't think there's any point in putting her on the stand. They could trick her up. She could come across differently, and you don't want that to further complicate how they see her.
Okay, very, very interesting. We'll be following this case here on Law and Crime, as you know. But we're going to take a break now, and when we come back, I'm going to bring you to another case that we're covering here, the case of Sean Finnean. This is truly one that's a horror show. I'm not sure the jurors are ready for what they're going to hear and what they've heard and seen. And this is the case involving the torture, the rape, the murder, the killing, the putting a victim in the freezer of somebody who truly was homeless and truly needed help. Instead, she was murdered, allegedly by Mr. Finnean and his roommate, a female, who's going to testify against him. And we're going to hear some of that testimony. Stay with us on the other side.